Social dancing, a fun little get together, a time when you can either dance with a total stranger or possibly a familiar face. You would think that something as innocent as dancing with another person in either the club or ballroom would be protected under the First Amendment, right? Freedom of speech, freedom of association. Well, due to a case, the City of Dallas versus Stingland in 1989, social dancing was removed from the First Amendment by the Supreme Court. This resulted in opponents of social dancing restrictions having no First Amendment ground on which to challenge the government restriction of an inherently expressive and associative activity. Previously, I mentioned the case of the City of Dallas versus Stanglin, and as I said before, this played a major role in social dancing being removed from the First Amendment protection. This all started when the City of Dallas, Texas, passed an ordinance regulating the ages of admitted patrons and hours of operation of dance halls. The owner of the Twilight Skating Rink in Dallas, Texas, Charles M. Stanglin, did as he was told and split his rink in two separate sections. One section for teens of the ages 14 to 18 years old, and the other section for anyone who was willing to pay the admission fee, which was about $2.50 to about $5. But then Stanglin wanted to sue the city to undivide his rink. He argued that the ordinance placing age restrictions on dance halls violated the First Amendment rights to freedom of association and the 14th Amendment's Equal Protection Clause. Stanglin argued that it was unconstitutional to the rights towards the due process and Equal Protection Clause of the persons between the ages 14 to 18 years old, that they were not able to associate with those outside their age bracket. But the trial court upheld the ordinance, finding that it was rationally related to the city's legitimate interest in ensuring the safety and welfare of children. It was also argued that although the First Amendment does not in terms protect right of association, but that it embraces such a right in certain circumstances. In another case, Roberts versus United States Jaycees, it's noted two different sorts of freedom of association that are protected by the U.S. Constitution. It was stated as, our decisions have referred to constitutionally protected freedom of association. In two distinct senses, in one line of decisions, the court has concluded that the choices to enter into and maintain certain intimate human relationships must be secured against undue intrusion by the state because of the role of such relationships in safeguarding the individual freedom of association receives protection as a fundamental element of personal liberty. In another set of decisions, the court has recognized a right to associate for the purpose of engaging in those activities protected by the First Amendment: speech, assembly, petition for the redress of grievances, and the exercise of religion. In the end, the court has decided about the case. As stated, we hold that the Dallas Ordinance does not infringe on any constitutionally protected right of association, and that a rational relationship exists between the age restriction of Class E dance halls and the city's interest in promoting the welfare of teenagers. The judgment of the Court of Appeals is therefore reversed, and the cause is remanded for further proceedings not inconsistent with this opinion. In together, they were just trying to protect the teens from getting involved with things such as drugs or alcohol, and they also found it rational the ages between 14 to 18, because you don't want 14-year-olds getting mixed up with 25-year-olds on their section of the rink. But in conclusion, I can see where Stanglin's reasoning is coming from for wanting to remove the divider in his rink. He thought it was unfair for younger teens being not being able to interact with older teens and adults. But I can also see why the city was trying to push so hard for this law. The city felt that if they could enforce restrictions in our limits with social dancing or other social occasions, that they could possibly help prevent younger teens getting involved with older teens and young adults with, as I said before, things such as drugs and alcohol and even sexual activity. When I look at it today, I believe that it is good that these restrictions exist with things such as the drinking age or smoking age, and that we don't have to argue with the First Amendment. Because when we look at it all together, they're just trying to protect us.